Hi, so a couple of months ago, I did a presentation with Belvedere Share Managers at the Tattersalls Club on just some estate planning stories, and I actually recorded it at the time on a video, but I didn't do it very well, and so I couldn't put the video out there. And I had a lot of feedback that people loved the stories I told, and they really wanted a recording of that. So this webcast is an attempt to recreate what I presented that night at the Belvedere Grow It, Build It, Protect It night. And there's been an update on one or two of the stories I told, so this one's newer and better, hopefully. So let's get started. So I was at a conference recently and ran into a lawyer I hadn't seen for a while. And I said, "What have you been up to?" And he said, "Oh, Kieran, I've had a few wealth transfer files on lately." And I said, "Oh yeah, what does that involve?" I thought he was helping hand wealth over to the next generation. But no, he was actually talking about the wealth being transferred from the testator or the will maker to the lawyer. With all the family fighting that was going on, it was the lawyers that were getting rich. So, he was enjoying these wealth transfer files. And it's one of the growing areas. Used to be personal injuries, and now it's all these disputes that are happening over estates. And more we're seeing superannuation too. So, your best protection is, to have your affairs in order in the first place rather than trying to be involved in and win a fight where it's only the lawyers who get rich. And so this has been on the news again lately, just about 2 days ago. So this was a case of a mining magnate. He died, and so he had several wives and several children to those wives. And he also had an illegitimate child, some time before that. And so this illegitimate child had really led a pretty plain vanilla life. She might have had her private school fees paid for by dad, but other than that, she just lived an ordinary life, certainly not a life of excess at all. And so this guy's estate, Mr. Wright's estate, was worth approximately $1 billion. So huge amounts. And, his legitimate children looked like they were getting about 400 million or so each. And so what was left to the illegitimate daughter, she was only 19 when he died, was a trust with the benefit of $3 million in it. However, this daughter wasn't in control of the trust, and the trust had some pretty funny terms in it, such as she might not be able to inherit if she takes up another religion. She won't inherit if she's been convicted of drink driving or has any alcohol problems, etc. So it wasn't like she got $3 million in the pocket. And so she made one of those claims for family provision, so for adequate provision from the will. And so in that claim, the lawyer said, "Oh, look, you better list what items and expenditure that you envisage that you'll need over your coming wife." And so as a 19-year-old, she was trying to think how the other half and how her siblings might live. And so she must have got online, and her list of requirements were a diamond-encrusted bass guitar worth about $250,000, a crystal grand piano worth about $1.5 million, a shoe budget of something like $5,000 a month, and all of these outrageous expenses. $1 million for the wedding she hadn't had, and all these kinds of expenses. And look, the judge in that case, he said, "You're only 19, your requests are quite fanciful." And the daughter, she was asking, instead of the $3 million in a trust, she was asking for $18 million personally. And the judge, despite these over-the-top demands for diamond-encrusted bass guitars, etc., the judge actually awarded her more than what she asked for, awarded her $18 million. He said, "Look, the $3 million was really just a rounding error in an estate of $1 billion, and $25 million in circumstances of what her siblings would have been receiving, was really not much at all. And so, in those circumstances, it was an appropriate award. And you see, in Australia, for family provision claims, the biggest successful family provision claim had only been for about $1.5 million. And so this was just blowing that out of the water. Having said that, most estates that were dealing with family provision claims weren't $1 billion estates. And so that was a real warning for everyone that, what's adequate provision when you've got a huge estate? Maybe, it's different for those people. But anyway, the siblings ended up appealing that decision, and that came down just last week in the appeal court of Western Australia. And so they actually reduced the award to $6 million. Now, the daughter had already gotten $3 million, and she bought, about $1.5 million home, and, it was generating some income from that $3 million. And the court actually said, well, look, especially considering your claims for these diamond encrusted bass guitars, etc., we're not going to give you the rest of that $6 million straight away. We're going to have it held by a court-appointed trustee to invest it wisely until you're 30. And how they had a look at how they determined $6 million is they said, look, it's not the court's role to really give you a percentage share or rewrite your father's will. Family provision claims are for giving adequate provision for your fair maintenance. And so they got an actuary involved, and the evidence of the actuary was well, look, $1.5 million home, and then the balance being invested should be able to generate a annuity for the rest of this girl's life expectancy of about $100,000 increased by average weekly wage earnings increases for the rest of her life. So theoretically, this $6 million was sufficient that this girl didn't really even have to work again. So it's still a huge claim by all Australian standards, blowing everything else out of the waters, but it's come back a bit more reasonably now. And so what that, $1 billion estate really blows most of our minds. But typically in these family provision claims, anyone who's making a claim who's got sufficient money or more than sufficient money, they're not going to be successful in making the claim. It's for the people who are truly dependent. And so what are other circumstances we might see a bit more commonly, when you're smaller estates? And that is the case of the parents who have for years looked after the bad egg child, bailed them out of jail, bailed them out of their debts several times, and they got a drug addiction problem. And so sometimes the parents have spent hundreds upon hundreds of thousands of dollars bailing this kid out, and they say, Kieran, look, enough's enough. I really want to cut this kid out of the world. And I say, look, unfortunately, it's because his siblings have, got a good job, a good income, and they've already got significant assets. This, the ice abuser has actually got a strong claim to make a family provision claim because they've got nothing and they've historically been dependent upon the testator. And so those are the circumstances where the no-win, no-fee lawyers will take on the claim and, act to try to get a bigger chunk out of the inheritance. And sometimes, on a small estate, they might be able to get the lion's share of their parents' inheritance. So the idea to try to minimise the risk of family provision claims for those people who have got, a specific risk in mind is to try to make their estate worth zero. And so how do they do that? Well, for example, their super. They pay the super, instead of to their estate, they pay it directly to the other adult children. They might set up trusts, and so a trust asset isn't an asset of the estate, and so they give the good children the control of that trust. And then for assets that are in their own names that are too expensive to transfer over to a home, they might do what's called a gift and loan back strategy. So they gift their equity over to a safe trust. The safe trust lends that back and takes a mortgage, say, over the home. So For example, if they had $1 million home, they'd do a gift of $1 million equity to the trust, and the trust would, instead of cashing that gift, would lend that back and take security over the home. So then when the no-win, no-fee estate lawyer comes along, the asset's $1 million, but there's a liability to a safe trust of $1 million too. So there's no estate to make a family provision claim over. And so I explain that concept in one of these animations that I've done in the gift and loan back strategy. Specifically in that animation, we're talking about trying to protect your assets from creditors, but it works equally well, protecting the assets from a potential family provision claimant. So the advantage there is we didn't incur capital gains tax and stamp duty, etc., by transferring those assets physically over to a trust. And watch that video. We've got a couple of cameo performances by Tom and Jackie at our work that are a bit amusing for the role playing. Now, we talk about wills a lot, but with the life expectancy going up and up, what we're seeing more and more of in practice is people losing capacity. So if you're living to 100, there's a much greater chance that you're still alive, but you don't have all your marbles anymore. And so we're seeing more and more circumstances of people losing that capacity. One example we had recently was the elderly father was in their 80s, I believe, was looking after his incapacitated wife, and so it was a full-time kind of caring job at home. And so one of the children came and actually took them both and committed them to the nursing home. And it wasn't until about a month later that the nursing home got the proper psychiatric assessment done of Dad, and the psychiatrist concluded that Dad had fine capacity, and so released him from the nursing home. And so he came out to find that his son had his house up for auction that coming Saturday. So we had to urgently act to try to prevent that from happening. So there's more and more cases of elder abuse, and a lot of people are focusing on making sure they've got their enduring powers of attorney in place and their advanced health directives. So if they lose capacity, they've not only got the right people controlling what happens, but they've thought of different scenarios, and they're really doing some much more focused planning on what would happen with their business affairs and their personal affairs and their health affairs in the event that they lose capacity. And if you're going to be in a position where you've lost capacity for 5 years, 10 years, it's so important. When you die, well, I guess you're not functioning anymore. When you lose capacity, you can come good, and your world can be very different if you haven't appointed the right people there. So that's a really growing area. Which brings us to superannuation. And here I've got a picture of a bird with no legs. And this is a case summary of Donovan and Donovan. So this was a Queensland case. Justice Freiberg was the judge back in 2009. And so in that case, Justice Freiberg compared the position of the average self-managed super fund member trying to navigate their way through the myriad of legislation and regulations and the framework of the tax law, etc. He compared their plight to that of the mythical Umadoodle bird. And so I looked that up and I thought, what's this Umadoodle bird? And this Umadoodle bird is named after the cry it makes every time it tries to land. And this is the bird with no legs. And look, in this case, this is one of those ones where the husband thought he'd done a nomination, a binding nomination, but because of the technicalities of how the deed was drafted, some superannuation regulations that usually apply to the bigger funds, not the self-managed funds, were incorporated, and the nomination didn't comply with those strict requirements. And so what that meant is the nomination, so that the members' superannuation benefits would go to his estate and his children from his first marriage, instead went to his second wife, who was also in the self-managed super fund with him. And where there's case and case and case again, the courts are taking such a technical approach with these nominations, and so it's so easy to get them wrong. They're even going, okay, well, they're having a look, was a deed of change of trustee effective? If it wasn't, well, the nomination wasn't effective because it wasn't done to the right trustee, etc. So they're going through every deed variation and dotting every I and crossing every T. So, if you are in that blended family situation, you can't muck around, and you've really got to get that proper advice to try to ensure that the nomination and your estate planning inside your superannuation is really up to scratch. And so that's not just making sure you've got a nomination in place, also making sure that the right people are in control of your super fund or your self-managed super fund after the members passed away. And we saw that there was those massive changes to the superannuation law and the tax law that largely kicked in on 1 July 2017. And so what that means, one of the bigger changes was your tax-free pensions now are limited to $1.6 million, to start off with. Other than that, the rest has got to be an accumulation. And so effectively what that also means is if someone passes away, the maximum that they can provide as a reversionary pension to their spouse is, what's in that pension account. So that $1.6 million, so to speak. So for those superannuants who have got super balances that are larger than that and they had to bring down their tax-free pension, they might have to have a look at their super fund estate planning to make sure that what's now in that accumulation account, that excess over the $1.6 million is adequately provided for in their estate planning. And that can also mean if we've got to get significant money out of super on the death of the first spouse now, is a lot of people didn't start their testamentary trust until both spouses had died because they could keep everything in super. So that's changed, and we need to update their wills quite often because for tax reasons, we really want testamentary trusts on the death of the first spouse. So we've got a good structure for all that super money that's coming out. And again, I've done another animation on how those super changes might warrant a revisit of those estate plans. Okay, so here's a case study that surprises most people. So this was a case of Andrew was 28 and his parents had lent him $100,000 or so over the years, including for the rental bond for his latest place. Andrew had met Stacey at a party in February, and when he caught up with the family for a family catch up in June, didn't even mention Stacey or having a girlfriend or anything. And so then he moved into a share house with Stacey and another lady in late October. And he died in late November. So only maximum kind of 6 weeks that they'd been cohabiting together. And kids nowadays, they might not even have a room together. It's hard to say whether that's a relationship. They might just be flatmates. So Andrew, he had superannuation benefits. And even though he didn't have much money, like a lot of younger Australians, they've got their super, and what's big in there is their insurance benefits. So he still had, an insurance policy that was paying out over $200,000 because of his death. Andrew also had a will leaving all of his estate to his sister. And so the trustee of Andrew's super fund, this was a retail fund or an industry fund, they determined, well, Stacey was his spouse, even though they'd only been cohabiting for maximum 6 weeks. And, sounds like a pretty amazing result considering we typically think of de factos of having to be together at least 2 years. That doesn't apply for the super environment. And so that got appealed to the Superannuation Complaints Tribunal and they agreed. Yeah, Stacey was a spouse, they were living together, and the Superannuation Complaints Tribunal and those larger funds, they always prefer paying to a dependent or a spouse over to paying to an estate or, and therefore to a parent or a sibling. And so the lesson for this is, young people, because of those insurance benefits, it's probably a good idea for them to do a binding nomination and to their estate. So then their super benefits or that insurance can go back to their family. And so a lot of times if we're seeing mum and dad and we're doing more complex estate planning and testamentary trust wills, sometimes they'll get their uni student kids in and, we'll do a one-page will and make sure they got a binding nomination in place just to make sure that the kids' super goes back to the parents, and so the parents aren't miffed at having spent all these hundreds of thousands of dollars on them over the years, and the kid's latest flatmate getting the benefit of that. So interesting case, hey. And I've got the reference for that superannuation complaints decision there, D96/011. All right, now the next topic is just dealing with how does intestacy work. And so here we've got Marley and Basil, and they got a little kid, Clayton. And the assets of the relationship are $1 million house in Basil's name, and Basil's also got $500,000 worth of shares. Basil dies, and he doesn't have a will. That's called intestacy. So the rules of intestacy, that means you get the state's will. And the rules of intestacy are the first $150,000 to the spouse, the household chattels, so your TVs and your couches, to the spouse, so to Marley, and then it gets split between Marley and Clayton after that. So Marley wouldn't be really impressed that half of the house is owned by Clayton. And this is the same story, even if it was Marley and Basil, and they were both 50 years old or 60-year-old and Clayton was an adult, it's still the same result. Suddenly, Clayton as an adult is entitled to half the family house. So, that's a scary situation for a lot of people, and hopefully it might motivate some people who don't have a will to think about getting one. All right, in this next one, so this is Claire and Phil had separated, recently separated, and then after separation, Phil got a $3 million inheritance. Claire received 50% of that inheritance in a property settlement. Now, that's not always the case that these windfall family court decisions go. That was certainly how the decision went in Singerson and Jones. So, parents really need to consider their estate planning. If one of the kids is going through a divorce, go and have a look at what methods they can do to protect their possible inheritance if they pass away from going to their ex-in-law, and they might want to have a look at some things they can do with that, even when there's no divorce that's imminent in their kids. And so we were involved in a case along those circumstances where the kid was going through an acrimonious divorce, and the mum had significant family money, and so she had a will that was giving the son the estate, this family money. And unfortunately, mum was in hospital, incapacitated, and had a short life expectancy, so she didn't have capacity to change her will to a testamentary trust with multiple trustees that would have given protection to make sure the inheritance didn't end up with the ex-spouse, so the son's ex-wife. And so we applied to the court to change the will to that type of testamentary trust, to make sure the family money stayed in the family and didn't go to the in-laws. At first instance we weren't successful, and then we appealed to the appeal court and we were successful. And so we've also got an animation on that one with Steve in his pinstripe suit, with some dramatic license of what happened in that case and how that went. So check that out. So you can still do, you can apply to the court to do wills for people when they don't have capacity to do those wills. Another example where that could happen is, for example, mum and dad had a child who was significantly injured when the child was quite young, and so the child got brain damage and was handicapped, and mum and dad had divorced, and so mum looked after the kid the whole time. Dad really had nothing to do with the son, and the son was 35 and looked like the son was going to die soon. So under the rules of intestacy, the son could never make a will because he didn't have capacity. Under the rules of intestacy, his inheritance, so the sizable inheritance, because he got a large payout from the personal injuries claim, the sizable inheritance would have been split between mum and dad. So mum applied to the court to say, look, if he did have capacity, because I've looked after him, he would have given all of the inheritance to me. And the court agreed with that. And there's other situations too. So when there's not capacity, we can go off to the court and apply for a court-ordered will. So look, so many people we speak to, they're saying, "Oh yeah, look, wills are important. I'll do that tomorrow. Worry about that later. Someone else will sort it out. Oh, I've got to make all these decisions first, or I've got to sort out my tax first, etc." Um, so look, you just got to go and get it done. In this video here, I talk about initial meeting with us. We got a fixed price initial meeting. Look, don't think that you've got to get everything done beforehand. In this meeting, I say, hey, why try to figure out all the solutions to your complicated saga before you come? Why not talk to someone who does this as a living? And, they might have some suggestions you hadn't thought of. So the main thing is just get it started. And so watch that video for, what to bring and what to expect at that initial meeting. And I also did another video a few years ago, might have been looking a bit younger back then, of the need nowadays with all of these changes in the law, all of these changes in the tax, all of these changes in people's circumstances. It seems to be happening quicker and quicker. So it's no longer a case of just doing a will and putting it in the drawer. We really do need to visit estate planning every couple of years really and have a good look at it, even if it's just to say, hey, everything still works and you still understand it. And so that's a video there. So we've got some packages that we can really help that process by, if you sign up to that package, booking into that regular review. And look, we've started to do a few more of these animations. I'm plugging them a bit in this webcast, and some of these on the testamentary trusts and how they work. And we've got a booklet, 9 Ways to Protect Your Family. And so we're trying to animate some of those case scenarios. So have a look at those ones on YouTube. We've also got them on Facebook, etc. too. And so the idea is you have good estate planning, have your super well sorted, and you understand what it does. And so then, unlike that Doodle bird, everything's in order and you're not crying when you hit the ground. So look, we're active on a few channels on YouTube. Subscribe to that for all those videos we put out there. LinkedIn we're active on too, and we've also got the Facebook account we're putting different things on. So whatever forum it is, would love you commenting, liking, all of that kind of stuff, having some kind of interaction so we know we're not just speaking to no one, so we can keep putting out this content and this kind of information. Also, if you'd like that brochure of 9 Ways to Protect Your Family, or just to have a chat, just get in touch with us. We put on seminars once a year, our client seminars, and we put on some webcasts, etc. too. If you want to get on the invite list for that, just shoot us an email or subscribe on the website, and we can invite you along to those functions that are entirely free. So anyway, thank you for the time for listening, and I hope to do a few more of these moving forward. I'd love your feedback on what topics interest you, so they can guide us in what to put on next. Thank you.